University of Liberal Arts, Bangladesh. I will be moderating the session today. I'd like to thank all our guests for joining and our panelists. Thank you for making the time to join the session. I'd like to introduce, so the purpose of this session the purpose of this session is actually to try to understand the nexus between the concepts of climate justice, international policies, court cases within the context of climate change that is resulting within the context of loss and damage resulting from climate change. So that's the purpose of this entire session. So that's what we're going to be trying to do. We have five esteemed panelists for the session today. Our first speaker is Dr. Arpita Kodiveri, Director of Research at the Center for Human Rights and Global Justice at the School of Law, New York University. She was a Fulbright Nehru Fellow at UC Berkeley, and she received her doctoral degree in law and European University Institute as a Hans Kelsen Fellow. Her research examines land conflicts, legal mobilization by forest-dwelling communities in India. She was previously practiced as an environmental lawyer in India, supporting forest-dwelling communities. Her presentation is going to be followed by Cesar Rodriguez Garavito. He's a professor of clinical law and chair of the Center for Human Rights and Global Justice at NYU School of Law. He's also the founding director of the Earth's Rights Advocacy Clinic, the Future of Rights Program, the Climate Litigation Accelerator, and the More Than Human Rights Project at NYU Law. Professor Rodriguez Garavito is a human rights and environmental justice scholar and practitioner whose work focuses on global governance, climate change, socioeconomic rights, business and human rights, indigenous peoples' rights, and human rights movement. Over to you, Dr. Arpita Kodiveri and Cesar Rodriguez Garavito. You may take the floor. Thank you.
Yeah, thank you so much. Just a slight change in the order, actually. So we're going to sort of begin with Cesar kind of giving us the broad brushstrokes of the human rights-based climate litigation and its rise globally. And then I'll step in to provide more of the South Asian perspective and the possibilities that it holds for loss and damage. So I'm just going to share the screen and open it up to Cesar.
Thanks, Arpi, and thanks, everyone. It's our pleasure to be here with esteemed colleagues with whom we're collaborating closely on new work in Bangladesh and elsewhere. Arpi and I will divide our short presentation into two aspects, two components. First, I'm going to walk you through the background information on rights-based climate litigation, basically a global overview of this exciting trend towards holding governments and to an increasing extent corporations for climate harms based on human rights law and arguments. And then Arpita, as she just mentioned, will give a regional overview and also point to blind spots and open questions. So, and this is all based on research that we have conducted here at the Climate Litigation Accelerator at NYU. And so if you could go to the next slide, RP, if folks are interested in looking at the data and taking a more granular look at the analysis and the case studies. This is the cover of an open source book that we published last year. I edited it, but with the participation of many practitioners and scholars, including Arpita, and it's called Litigating the Climate Emergency. And it's open access, and this is the cover of the book. So if you could go to the next slide, Arpita, I'm just gonna use one slide that gives you a sense of the trend. And I won't go into the details. We don't have time to go into the details and look at the cases. Happy to do that if there's interest later on. But what I'm interested in highlighting here is the trend, right? This is the case count of human rights-based climate lawsuits that have been filed before domestic, regional, and global courts and quasi-courts. And so by quasi-courts, I mean organs like an international human rights bodies like the UN Human Rights Committee that last year handed down its recommendation, its decision on a path-breaking case on the responsibility of Australia for lack of climate action that has harmed indigenous peoples in the Torres Island. So as you can see, there were very few cases of this type until 2015. And this is no coincidence. The Paris Agreement 2015 and also the expansive and increasing trend towards using human rights arguments before courts, kind of those two developments intersected and converged around 2015. And what's happened since is that activists, lawyers, NGOs, both in the environmental and the human rights fields, have developed novel doctrines or used existing doctrines, existing tools, like the rights of future generations, the right to health, for example, that's the right to life, that's heavily and directly affected by climate harms, to push their governments and some corporations to do much more against climate change in line with the recommendations of science. Right. So in a nutshell, this development, and again, I don't have time to go into the details of any cases, but in a nutshell, the trend is towards cases that use the global targets, the global pledges that states and increasingly corporations have signed off to, and turn them into binding duties at the domestic level. As we all know, corporate targets are voluntary. State promises to cut down emissions are also non-binding. So what lawyers have been done around the world is try to find ways to hold those actors accountable to their pledges. And this is the gist of climate change litigation based on human rights. I'll end by pointing out some interesting trends here. By the way, if anyone's interested in looking also at the primary data, you can go to clxtoolkit.com, where we maintain an updated database of all the cases. At this point, there are around 200 filed around the world. But in terms of the regional distribution here in the upper right-hand side corner, a third of the cases have been filed in Europe. And because of a unique combination of a strong regional human rights agreement, the European Convention, with strong court, and also strong courts at the domestic level that have handed down decisions in cases like Urgenda, which is one of the pioneering cases in this trend in the Netherlands. But in countries in the global south, in Latin America, in Southeast Asia, and also in Africa increasingly, this trend is picking up. So this is by no means a global north phenomenon. It is spreading around the world, and it holds considerable potential for scaling up and speeding up climate action. And finally, if you look at the chart at the bottom, the right-hand side, you will see that despite the fact that this is a relatively young trend and lawyers and judges tend to change their minds very slowly and gradually, sometimes too slowly and gradually, as compared to the urgency of the situation with climate change. But even so, even though this trend is 8 years old, most of the litigations happened in the last 8 years, courts and lawyers and litigants have changed their minds pretty quickly. And in terms of the outcomes, there's a technical tie between cases that have gone for the plaintiffs and cases that have gone for governments and corporations as defendants in terms of those rulings, of those cases that have ended already with definitive rulings. Of course, most of the cases are still pending or on appeal because they take years to make their way through courts. But this is an encouraging trend. Novel doctrines, like, for example, the fair share principle, meaning that each government, every government, needs to contribute its share of climate emission reductions, regardless of what anyone else does. Right? So it's not a matter of the usual defense of governments is that, well, the Dutch government can make spectacular gains on climate change emission reductions, and yet that won't make a dent on climate change because this is a global phenomenon. So unless China and the US and everyone else do their part, then the reduction of emissions in the Netherlands doesn't make a difference. Well, judges and lawyers are increasingly moving towards the perspective that there is a self-sustaining, kind of a self-contained duty of every state, of every corporation to contribute its fair share towards climate mitigation. I'll stop there because RP is going to point to some of the pending issues like adaptation and loss and damage that, of course, are particularly relevant in this conversation.
Thank you so much, Cesar. I think, as Cesar mentioned, one of the things I'm going to be doing is trying to contextualize this rise of human rights-based climate litigation and see what the South Asian context looks like from that perspective. I think one thing to note is, and probably everybody in the audience and the other panelists are well aware, is that South Asia has pioneered some of the most exciting jurisprudence around human rights-based environmental claims. And so this is just like a overview of some of the key cases. In Pakistan, there's the Ligari case where the farmer held the state accountable for the non-implementation of climate policy. The court went up to the extent of saying that non-implementation of that climate change policy was actually violating the fundamental rights of the citizens. The second case, I think Momita is probably going to be speaking about in a lot more detail and probably giving us more nuance around it. But this case, of course, opened up locus standi in the country of Bangladesh, which meant that there has been a slew of public interest litigation around environmental issues. It also pioneered the environmental impact assessment policy and opened it up to local communities again. In the Indian context, we've had some experiments with climate litigation. So the Pandey versus Government of India case is still pending, but it's an interesting one because similar to the Ligari case, it tries to hold the government accountable for non-implementation of environmental laws, which in turn result in climate harm and human rights violations. So in some sense, the South Asian context is ripe for climate litigation. It's just not seen as many cases yet, but that's, as we see the global trend, I think it's only a matter of time that these legal adventures begin in the South Asian context as well. Some of the gaps that CLX has identified through its research on sort of the global landscape of climate litigation is, of course, the lack of cases that focus exclusively on adaptation and adaptation issues. Loss and damage, which I'll sort of focus on in the remainder of this presentation. And the third, I think, as Cesar also mentioned, is trying to hold corporations accountable. I think there has been emphasis within climate litigation to hold the state accountable, which is very, very important. But in terms of corporate targets, it's been lacking, and specifically certain areas, certain sectors, so industrial agriculture, clothing, and others. We're just going to quickly wrap up in some sense by talking about the possibilities that climate litigation holds for the issue of loss and damage, because I think that's where we sort of align. Our partnership sort of is situated in that, issue of injustice, and it brings together the role that climate litigation can play in addressing an issue of grave climate injustice. So one of the issues to note about loss and damage, and I'm sure Hafiz will speak to it a lot more, is there's been a glacial pace of negotiations. It's only in the last COP that we saw that the fund was negotiated. But despite that, negotiations hasn't really led to any concrete legal outcomes or possibilities for climate victims on the ground, especially since compensation and liability are eliminated from the possibility of even coming into the negotiation realm. And so litigation, I think, fills a very interesting gap. So what it does is it at least allows for the language of climate compensation and access to justice for climate victims to be both argued and potentially remedied. And that's sort of the ambitious sort of arc of justice here. The other interesting function that climate litigation serves in this context is holding corporations accountable, because within the realm of negotiations, it's very easy to get the states to contribute to loss and damage. But again, that's very politicized. It's got its own baggage of issues, which is probably Hafiz's everyday reality. So he'll speak to it a lot more. But I think what litigation does is it allows for companies to be held accountable for loss and damage based on the amount of contribution that they've perhaps made to the global carbon stock or to climate change more specifically. The other thing that litigation can potentially achieve is also to push and prod negotiations. So even if the fund has been negotiated, I think the threat of litigation and progressive legal possibilities that litigation can pioneer can potentially inform and push negotiations in a more progressive direction. And just to conclude, to say that I think the arena of climate litigation is going to be seeing a lot more cases on loss and damage. So where climate victims directly take corporations to court and to see what kinds of outcomes. And potentially these cases are going to be, scattered across the jurisdictions of the global north and south. And I think in the South Asian context in particular, it's interesting since the courts have always responded quite effectively to claims of remediation of environmental harm. So we'll have to wait and watch, and that's where our forces come together, so to speak, and we'll see what happens. So I'm going to stop there. I'll also just share links to the resources that we have at CLX for the audience.
Thank you, Professor Cesar Rodriguez Garavito and Dr. Arpita Godiveri. I think you both brought to our attention what the current state of climate litigation looks like, both at the international level and the fact that climate litigation is increasing. And it's good to know that climate litigation is, has had a good, we've had good climate litigation cases in this part of the world, that is in South Asia. So looking forward to more such cases coming forward, not just in South Asia, but also in the global, more cases, of course, in the global north. I'd like now to introduce our next speaker. Our next speaker is Advocate Moumita Dasgupta. She's practicing in the High Court Division of the Supreme Court of Bangladesh and also working as a research fellow the Center for Climate Justice Bangladesh. She completed her honors and master's in LLM, both from the Department of Law and from the University of Chittagong. She's worked with Bangladesh Legal Aid and Services Trust, that's BLAST, as a community justice fellow with a focus on climate displacement in Bangladesh. She also has a diploma on climate change and international law from the Aristotle University in Greece. Over to you, Moumita Dasgupta. You have the floor.
Thank you. Actually, I'm feeling nervous. So I'm going to talk about locally led adaptation, G4CR project, and litigation in practice to ensure climate justice in Bangladesh. And all you know that Bangladesh is affected with different adversities of climate change. Sea level rise and increasing salinity are two of those. Coastal region of Bangladesh is highly affected by these adversities. At the southwest Bangladesh, Satkhira is one of those affected districts. Governance for Climate Resilience G4CR project is being implemented at Satkhira in collaboration with Center for Climate Justice Bangladesh, Center for Natural Resources Studies, and ICAT, with support from CJRF since 2017. Ensuring fresh water flow is highly recognized as one of the several ways to reduce salinity. At the first phase of G4CR project, it was found that the vulnerable communities of Satkhira are facing trouble to ensure fresh water flow due to some lawsuits at the local courts. So Center for Climate Justice Bangladesh decided to provide legal aid to help the vulnerable communities at this area. Thus, the second phase of G4CR project got started. At the second phase of G4CR project, it was found that locally a handful of rich and influential people are taking lease of the canals from the government. These canals are freshwater bodies and a huge number of community people are depending on those for their agricultural activities, cattle raising, poultry farming, and fishing of natural fishes and other activities to support their lives and livelihoods. However, the leaseholders create obstacles for freshwater flow for fish farming by fish farming which is adversely affecting all those activities and destroying freshwater biodiversities. The obstacles of water flow with help of bamboo fences and nets, which are so closely braided that even if a fish egg cannot go out of the enclosure. Locally, it is called net pata. The government has banned use of net pata in open water flows. Thus, due to misuse of lease allotment, the government has cancelled several leases time to time. In response of that, the leaseholder are suing the government by claiming that the lease cancellation order is null and void, and the court should issue permanent injunction against the government to protect the leaseholders from being evicted illegally. Sorry. So, in this situation, if we see the Apex Court of Bangladesh, the constitutional amendment and Fifth Amendment has inserted Article 18A at the Constitution of the People's Republic of Bangladesh, which is headed as protection and improvement of environment and biodiversity. Even before inclusion of such provision, both of the Appellate Division and the High Court Division of the Supreme Court of Bangladesh have passed numbers of judgments and orders by supporting environmental rights of the citizens of the country. While deciding the groundbreaking case of Dr. Muhyiddin Farooq versus Bangladesh, the Appellate Division of the Supreme Court of Bangladesh has discussed about Rio Declaration 1992. The case was decided in 1997, and it is much before the constitutional amendment of 2011. Following this instance, public interest environmental litigation have grown in Bangladesh, and recent instance of government of People's Republic of Bangladesh and others versus Mushfaqur Rahman and another has found that on the basis of Article 18A of the Constitution, cancellation of leases to protect ecologically critical areas are justified. And for consequential losses, the leaseholder can claim only compensation from the government and cannot claim that the order is null and void. So this is from the Appellate Division of Bangladesh. So in this context, while moving forward with G4CR project, in 2020 and 2021, Center for Climate Justice Bangladesh has went to the field and had some field works with focus group discussion and key informant interviews, and we found the files of courts to see how the litigations are going on there, and we communicated with the government pleaders, and we helped them to move on with the cases. And actually, they were not informed about those cases, but those are being filed in the courts. So we asked them to look after those cases, and we communicated with the seniors communicated with the local government authorities, and they helped us to help the communities to canal recovery, and So we had several meetups with the local government authorities. And in the second step, just last year, we provided training. We provided 4 days training and 25 people for each day. We tried to make aware them about their legal rights and remedies and what can they do if they face any difficulties and where can they go. Again, we have communicated with the local government authorities and also the central government authorities, national government authorities in the Ministry of Planning. So that's how it is moving, and in future there is a possibility to communicate with the Ministry of Land also. So this is the progress so far, and thank you for staying with me. Thanks.
Thank you, Momita Dasgupta, for that wonderful presentation. It's good to know that things are moving along in the right direction in Bangladesh. Hopefully, we will see more such instances from Bangladesh as well. I would like now to invite Advocate. Sorry, my connection is a bit poor.
Tahura, still, are you there?
Can you hear me?
Yeah,
Hello?
now we do hear you.
Okay, all right. So I'd like to now call upon Advocate Muhammad Hafizul Islam Khan. He is an environmental lawyer affiliated with the Supreme Court of Bangladesh, and is also the director of Center for Climate Justice. He's been working on legal and policy issues related to the environment, natural resource management, and climate change for the last 18 years at local, national, and international levels. He's also been involved with drafting various national legislation policies and plans, and was also involved with formulating the National Adaptation Plan of Bangladesh. He was also involved in the drafting of the Paris Agreement. Hafiz Khan has also been a climate negotiator with the Bangladesh delegation for the past 15 years, and is now acting as the co-coordinator representing 48 countries for the loss and damage team of the least developed countries group at the UNFCCC. Hafiz, sir, it's over to you. The floor is yours.
Thank you, Tara, for so warm introduction. It was too long. I was really embarrassed. So, colleagues, hello. Good afternoon from Dhaka, Bangladesh. So, I was trying to hear carefully what Dr. Arpita, Professor Cesar, and Momita highlighted. So, basically, if we look at the climate justice perception, then polluter pay principle is the basis for this justice perception. So polluter pay principle, then again, based on the liability and compensation approach.
You're muted. Your camera goes off.
Oh, do you hear me?
Hello?
I'm sorry for that. I had some internet difficulties. So, colleagues, do you hear me now?
Yes, we can hear you, sir.
I'm sorry. Actually, what I was trying to say that the climate justice perception is based on the polluter pay principle. But polluter pay principle then again based on the liability and compensation. So this liability and compensation debates, it is moving towards the through the two avenues. Under the UNFCCC process, where we are trying to shape up the climate governance regime, they are trying to introduce this climate justice concept, and secondly, the court cases. As Professor Cesar talked about the different avenues and different jurisdictions, the current state of litigations are moving. He talked about the Argenta case in Netherlands, where the state responsibility was recognized and polluter countries made responsible to take high ambitions to reduce the greenhouse gas emission. On the other hand, if you look at the WRA case in Germany, that recognized the polluter companies, corporations, and to pay the affected farmer from Peru. So yeah, you see the polluter pay principle is moving, I would say, in a constructive manner within the different jurisdictions of the court. On the other hand, if we now look at the UNFCCC processes, we do see under the convention, historical responsibility was recognized, also common but and differentiated responsibility and respective capacities was also in the convention. But however, polluter pay principle was not recognized in the convention. But interestingly, later in the Paris Agreement, the climate justice was recognized even in the preambular paragraphs of the Paris Agreement, but it is recognized over there. Now, if we look at the loss and damage regime, that would give us a clear idea where we are in terms of addressing the climate justice context in the UNFCCC policy regime. So if we, can I share my slides? Tahura, Momita, can I share my slides?
Yes, of course you can.
Yes,
Okay, please.
that is beside the chat option you just share
Okay,
screen.
Momita, can you do it for me so that I can continue the talk? So what I was trying to tell that is under the UNFCCC process, there is a Warsaw International Mechanism was established back in 2013. But that the Warsaw mechanism was established under the adaptation framework. But Paris Agreement adopted a standalone article, that is Article 8, but still anchored the Warsaw International Mechanism. So now the Warsaw International Mechanism as in institutions is governed by the two international policy instruments. One is the United Nations Convention on Climate Change and second is the Paris Agreement. But again, the debates concern about the liability and compensations are associated here. And the developed country parties would like to bring these institutions solely under the Paris Agreement, just to avoid the compensation and liability debates. Colleagues, you might know that the decision paragraph, decision 1 CP 21, paragraph 51, that stated Article 8 does not provide the liability and compensation basis for the Article 8. With that understanding, developed country parties would like to anchor the Warsaw International Mechanism solely under the Paris Agreement. On the other hand, developed country parties, they would like to have the dual governance, both under the UNFCCC and both under the Paris Agreement. So this is a bit contentious issues are moving at this moment at the UNFCCC processes in terms of governance of the Warsaw International Mechanism, considering the liability and compensation approaches. However, colleagues, I would like to inform that as an executive member of the Warsaw International Mechanism, I would like to inform that Warsaw International Mechanism is now working with 5 streams. So the current ruling work plan of the executive committee, they are taking a broader aspect of society approach. In terms of societal approach, executive committee considering their work plan regarding loss of territories, cultural heritage, social identity or cultural identity, and of course indigenous traditional knowledge. And at the individual level, it is considering the human mobility and damage to health, and of course loss of life. But within the broader context of environment, it is also considering the slow onset processes, also non-economic loss and damage within the perception context of biodiversity and ecosystem services. Move with the next slide, please. So this is how I was talking about the executive committee that is working with more 4 expert groups and 1 task force, those established under the executive committee. The expert groups are established for action and support and non-economic loss and damage, comprehensive risk management, and there is a task force for displacement. This is how executive committee is currently working with its executive expert groups. And colleagues, COP27 decision gave us a momentum for climate regime that established a fund. But before that, colleagues, I would like to share with you that Santiago network was structured, agreed at Madrid. However, it was now institutionally designed at COP27. Now it's going to be operationalized next year. So COP27 decision regarding Santiago network, that is the technical arm of the mechanism, is now structured and going to be operationalized. Most interestingly, the global community agreed to establish a loss and damage fund, and then fund. Now the question is how to design this fund and funding arrangement. There is a transitional committee is established. Transitional committee is now going to meet first time end of this month in Egypt, and this transitional committee is going to make some recommendations for the parties to decide at COP28. But if we do consider the activities of the transitional committee, they're going to meet thrice in this year. Also, they would like to hear the 2 technical workshops, also Glasgow dialogues. These activities will inform the transitional committee to make some recommendations. Finally, the ministerial consultation before the COP, and at COP26, parties to decide further. So in terms of policy regime to address the loss and damage in absence of liability and compensation approach, CCC is moving, I would say, now satisfactorily, because the Warsaw International Mechanism now going to be completed, I would say, an international mechanism. Now EXCOM is acting as a policy arm. Santiago Network would act as a technical arm to provide technical assistance to the vulnerable developing countries, and thirdly, funding arrangement would provide the financial resources to address the loss and damage. I do see Chad, Professor Salim wants to know whether I'm going to attend the transitional committee meeting. And colleagues, I'm very happy to share with you that LDC, the 48 countries have nominated me as an advisor to the transitional committee members of the least developing countries. So I'm going to visit Egypt and to attend this meeting as an advisor. So I would like to stop here, and I would be happy to respond any other questions. I think about this slide I already talked about. So I can stop here, and I'd be happy to respond any of the questions later after Professor Salim's statements. Thank you.
Thank you, Hafiz sir, for that wonderful bringing together everything that's happening at the international level. We look forward to more conversation coming along after this presentation. I would now like to call upon a person, our next speaker. He requires literally no introduction. Dr. Salimul Haq is the director of the International Center for Climate Change and Development since 2009. Dr. Haq is also the senior fellow at the International Institute for Environment and Development, where he's involved in building negotiating capacity and supporting the engagement of least developed countries in UNFCCC, including negotiator training workshops for LDC, policy briefing and support for the Adaptation Fund Board, as well as research into vulnerability and adaptation to climate change in least developed countries. I could go on and on about his accomplishments, but I'd actually, it would take out the time of our session, but so I'll stop here and allow Dr. Haq to take over. Over to you, sir.
Thank you very much, Taura, and thank you for inviting me to say a few words in this excellent session. So I'm going to try and frame where I feel we are at this point in time on the topic of loss and damage. And I often refer to my perception and my view of the era of loss and damage we have now entered. And it is going to continue. every single day we will see something happening. And I can just share with you, early in the morning today, I participated in a session, a Gobeshona session, run by the government of Vanuatu. We had the minister of Vanuatu from Port Vila in Vanuatu, and we had the permanent representative of Vanuatu in the United Nations in New York. Both speak. The government spokesman from Vanuatu told us about 2 cyclones that hit them, one after the other, within a matter of days. And they are totally devastated in the country. But Vanuatu is not staying idle. They, in the United Nations General Assembly, they have tabled a resolution for asking the General Assembly for an advisory opinion from the International Court of Justice. This opinion, the resolution, has been gathering support. More than 100 countries have already offered to support it, which means that on a majority rule, we will win. For a majority rule decision, we need 91 countries. We have them. But what we want to do now is to get 100% consensus decision. We want every country to agree. And we have from now until 29th of March, morning New York time, when there will be a vote. We hope that when that happens, every country will agree, and we will have a unanimous agreement to ask the International Court of Justice for an advisory opinion. So that is a very important international human rights law track that until now had not been utilized. And we are very, very hopeful that we will be able to utilize it. Once we get that vote on the 29th, either unanimous or majority, I'm pretty sure we will not lose that vote. We will win by a majority if they force a vote. We will win by consensus if everybody agrees. And that's what we're trying to do now, win by consensus. Then the International Court of Justice will take up the issue and will solicit opinion from various sources. And one of the things that I would suggest that our team here on this call, who are working together, think about preparing some submissions to the International Court of Justice, as in when it invites amicus curiae interventions and submissions. So that's a new avenue under human rights law, under international human rights law, under the International Court of Justice. And then the ones that we have heard about here, which are case law, petitioners suing somebody either under national jurisdictions within the country, citizens of one country suing somebody else, either a company or their own government, and a few international jurisdiction cases from one country to another. The injured party being in one country, the perpetrator, polluter, against whom they are putting a case in another country. I just learned of a new one. I'm not sure everybody here knows about it. We had a visitor from Switzerland just a few days ago here in Dhaka, who has been working on litigation in Switzerland against the Swiss-based global cement manufacturer, Holcim, who is the world's biggest cement manufacturer, and whose global emissions are bigger than Switzerland's emissions. And so they are taking Holcim to court in Switzerland using a plaintiff from Indonesia. These are a group of people living on an island in Indonesia. He came to Dhaka from Indonesia, where he had been working with them and talking to them and preparing them to be the litigants. And they are now going to put a case in Netherlands, in the Swiss law in Switzerland, against Holcim. And this evidently, he told us, has already caused a lot of controversy and publicity in Switzerland, with companies now thinking, what is this? Am I going to get sued next? And companies are, putting their thinking caps on and saying whether or not they can be sued, they can be made liable or not made liable. And so, in my view, the opportunity to put these kinds of global cases is very, very good in terms of raising awareness. If they win in the courts, that's 100 times even better result. But they don't have to win in the courts. They have to just go through the legal system from the lowest level to a higher level and a higher level and a higher level, as we see with the Peruvian farmer suing the German energy company in Germany. We need a lot more of these kinds of cases to go ahead and to test the human rights aspects of climate change under national law, under international law, because, and I'll come back to the UNFCCC process, because that does not work in the UNFCCC. The UNFCCC, unfortunately for us, the vulnerable countries, is a consensus-based negotiating group. It's not a court of law. There's no law here. We've just agreements. And if somebody doesn't abide by the agreement, we can't do anything about it. It's just name and shame. That's all. And they don't get shamed. So we had the Kyoto Agreement. The US walked out of it. No shame. Canada failed to adhere to their agreement. They agreed, but they failed to fulfill their agreement. They left. No shame. So they agree to do something and then they don't do it, and they don't feel any shame. So the ability for us to put pressure on the polluters in the UNFCCC framework is very, very limited. And under those circumstances, the fact that we got the decision in Sharm el-Sheikh and everybody agreed to set up the fund, in my view, was a very big breakthrough, because we've been asking for that for many, many years with no success. But we got it. So we have to build on that. And it's not perfect. We don't have any money yet. It has been likened to, they've given us a bucket, empty bucket, no money in the bucket, but we have the bucket called Loss and Damage Fund. So now let's see whether we can put some money into it and where the money can come from, and then who can get that money. So at least we have a beginning. We have the transitional committee. They're going to meet. It's very good that Hafiz, very good news, Hafiz. I'm very glad to hear that you can go to Sharm el-Sheikh, Egypt, for the TC committee meeting. I had wanted to go, but I can't go physically. And I'm told that they won't allow observers online. This is something we should protest. Because normally in the Warsaw International Mechanism, XCOM, you know that, we are allowed to come as online observers. Maybe not for every single session. You can have closed sessions if you want. But in principle, online observers should be allowed. And that is the normal practice in the UNFCCC for these kinds of committees. So I don't know why the transitional committee has been made into an in-person observer only. And I understand that there are limits on numbers from constituencies as well. So I would urge you, Hafiz, to urge our transitional committee members to protest very, very strongly against this arbitrary decision. So whoever made the decision, the committee is the final say for the decision. And they should not be making any decisions without the committee having met and made that decision. So please push that particular point in terms of participation. They cannot be a bad example for stopping participation or hindering participation. They should set a good example of encouraging participation. So anyway, I'll stop there. Just conclude by saying that we are just at the beginning of many, many different things that are going to happen. From our side, we are very keen to participate in everything that we can. We have limited bandwidth, but we have an interest, huge interest, very ambitious interest to join forces and work with others, to collaborate. We're going to have to collaborate to do this. Nobody can do it on their own. And we are very open to collaboration. And we look forward to working with all our partners, taking all of these issues forward. I'll hand it back to Tahura.
Thank you, sir, so much for that wonderful, passionate explanation of what's actually taking place and what we expect to happen, what we expect to take place in the future. Absolutely agree. Yes, we do have to start somewhere. And about the bucket, yes, it may be empty at the moment, but I think with people that are there in today's panelists like Dr. Haq, Hafiz Khan, and Cesar Rodriguez, and Momita, and Arpita, ma'am, I don't think that bucket is going to stay empty for long. It's definitely going to get filled up. I would now like to invite our attendees if they have any questions to ask to our panelists. You may ask your questions now. You may raise your hand, or you may write down your questions in the chat box in the Q&A to any of the panelists that we have had. So please go ahead, ask away. Okay, so I actually had a question to Dr. Arpita when she presented her presentation. So one of the things that we have had was, you mentioned that the fact that in South Asia, we've had already plenty of cases that where courts actually give priority to the environment or taking care of the environment. So wanted to know what is actually the current situation in terms of climate litigation. One is environmental litigation, one is climate litigation. So what is the current situation of climate jurisprudence in South Asia? And does the current existing infrastructure support climate litigation? What's your experience telling you about climate litigation in South Asia?
Those are great questions. I think what's fascinating about the South Asian context is that climate jurisprudence is kind of hidden within the growth of very interesting environmental jurisprudence. So there hasn't been a separation as such between environmental litigation and climate litigation. That's not to say that the infrastructure doesn't allow for it. I just think that the strategy that lawyers on the ground seem to be going with is using existing environmental laws with sort of a climate tack on and a climate argument tack on. But I don't know how far that strategy is going to serve. So the opening up of a separate kind of category of litigation in terms of climate litigation is something that we're going to see. It's just, I think it's also one of those legal movements that start in the global north, but then the global south sort of begins, or it exists, but starts to sort of match up in a very interesting way. I think the possibilities which are very, very exciting in terms of the South Asian context is the enabling infrastructure, the expanded locus standi, judicial activism, which has been very strong. And the fact that courts have been instrumental in taking international environmental law and merging it with very strong domestic environmental laws. So these are existing parts of the court's DNA. So they can just harness that and use it. And obviously, the South Asian region is very vulnerable, whether it was the floods in Pakistan or sea level rise in Bangladesh or heat waves in India. I think I think the courts are going to react, possibly reacting in very subtle ways, but I think it's going to react more strongly in the future. And we'll see more cases coming to the courts.
So do you think we need to push for a separate climate litigation scenario where there is more and more cases coming just to address the climate change impacts, the vulnerabilities that communities are facing? Communities can bring a case solely on just climate. Because of climate change, they are bringing the cases to courts. Do you think that avenue can open up in any of these South Asian countries? If so, where do you think it's the most progressive, where we can see more of climate litigation cases coming forward?
I think definitely there is that possibility. I do think that, with communities specifically bringing a climate claim, you would probably see more cases on adaptation and loss and damage and not so much on mitigation because it's such a thorny issue and then it gets politicized very differently. So I think you'll have communities possibly using more traditional legal arguments like protection of land rights or anti-deforestation movements. So that will continue to happen. I think there will be environmental litigation which will have climate benefits and climate justice benefits. But I think this idea of a pure climate claim we'll start to see on adaptation and loss and damage. In terms of the countries where I see this really growing, I would say that in countries like Sri Lanka, Bangladesh, and India, because the locus standi is so broad. I think that PILs haven't been harnessed yet, but I think now with the growing awareness around climate litigation, it is going to happen. It's just a matter of time.
Thank you so much. I think that sort of answers the question that I've been looking for. So the other thing that I actually wanted to pay attention to, I think I would bring Hafiz, sir, if you could answer this question. I wanted to know how, for example, NGOs and national frameworks, how for the case study that Dr. Huck mentioned about Holcim being brought to court by an Indonesian community, an Indonesian farmer. How can local communities, how can NGOs within the country and the infrastructure within the country in terms of the national framework help local communities in bringing some more and more such cases at the international level, supporting local communities to bring such cases at the international level? Is there any framework that that can help local communities do that? What's your experience telling you?
That's an excellent question, I would say. So if you look at the Peruvian farmer case, that the farmer filed case to the German court against the RWI company, that's the electric company from Germany, and court admitted that case, and that's still pending. Second, what Dr. Salim said about the case filed in the Switzerland by some of the islanders from the Indonesia, and they also claim some sort of loss and damage they faced due to the climate change impacts. That's also very interesting case. Similar case also we would like to bring to different jurisdictions, maybe in Europe or even in America, Australia or Canada. So we are going to collaborate with New York Law School, University of New York, also ICARD and Center for Climate Justice. And we are going to initiate a comprehensive study, hopefully next month, so that we can identify right plaintiffs and right jurisdictions and avenues to file the cases. So this would be an international case. At the same time, we can also try to look at the local jurisdiction, how we can establish the case by the vulnerable communities. For example, maybe to the court, but actually we are not the polluter countries, and what gonna court say about this victim. So that would be interesting. That would be a kind of legal recognition. This is how we are thinking at this moment to move it forward. Thank you.
Excellent. I think because it has not been, we have not had so long of experience practicing this kind of international climate litigation within the field of climate change. It's still a very new field of that people are exploring and people are learning more about. If I could put the same question to Professor Cesar Rodriguez, if you could bring in your perspective, how can we support local communities or national, how can we build the national framework to bring such more international litigation cases against these companies who are actually polluting and causing, been responsible for so much of the greenhouse gas emissions? What can we actually do at the local level, at the national level, to bring more such cases, possibly open up the door for more such cases? If you could just give your perspective here.
Yeah, happy to do that. And actually, this ties nicely into what Hafiz was saying about the work that will be launching very soon, the collaboration that will be launching very soon, because that is designed to address some of the needs and gaps in terms of both relationships with communities and also legal strategy that we feel helps explain the dearth of cases on adaptation and, more importantly, loss and damage for their current purposes. So one thing is the disconnect. We need to bridge the work of legal strategy, international legal strategy, that tends to happen. Those conversations tend to happen in places like New York or London or Geneva and elsewhere, and the world and the lives of communities that are directly impacted by climate change and that have been for a while now without the world paying much attention because they're usually located far from those centers of power. So this is the fieldwork component that needs to happen. It's a bit more time consuming and also less convenient than staying in places like the ones that I described, but we feel that this is essential. And the second component, just for the sake of brevity here, is to expand. So to expand the existing legal doctrines and adapt existing legal doctrines and even develop new doctrines that address the limitations of existing law. I will give just one example. So, and since some of my colleagues here have mentioned the RW case in Germany, that case is a good example of challenging a stumbling block in the law, which is extraterritorial obligations and global planetary impacts of carbon emissions. So by doing something that's heterodox, according to the mainstream view of the law and state responsibility and corporate responsibility, meaning suing an emitter for harms that are happening across the ocean on the other side of the world, the litigants have pushed the boundary in and invited, nudged courts to deal with the unique nature of climate change, which is very different from other forms of responsibility, from acts like war or pollution and that happens locally. And that, I think, is crucial. So we will need to both use the existing law and also come up with new doctrines. And this is where international law and creative interpretations come in.
Okay, all right, thank you so much. I think we're going to see, like you said, we're going to see more and more cases of these kinds coming up. And yes, we do need to do the background work, the initial groundwork, the slow, tedious work that needs to be done before we actually see more cases coming at the international level, and more so at the local level as well. In the national frameworks, we could see more of those cases. So hopefully we actually get to see more such cases coming to our attention, and we can bring more companies at least find ways to bring some sort of justice to communities that are suffering at the forefront of climate change. So if you have any questions, we would like to answer them. If anybody has any questions, please do raise your hand. Okay, I think we can close, come to a conclusion here. Thank you so much, everyone. Professor Cesar Rodriguez, thank you so much for your time. Hafiz Khan, sir, so thank you so much. Dr. Arpita Kotiberi, also thank you so much. And Momitapa, also thank you very much for your time and giving such valuable input. We'll definitely think about, we will work to definitely come to, how we can organize the session in the workshop. We will work in the future, bringing that together, and hopefully we will actually come together and bring something that we can work with. If we can bring, everybody can switch on their cameras, we can actually take a photograph just commemorating this session. So. Sumaya Apu, are you taking the picture?
Yeah, me and the IT team also are taking the picture. Just
Okay.
wait for it. Yeah.
Are we
I
done?
think we are good.
Okay,
Yeah.
all right. Thank you so much,
you.
everyone. Again, I hope you have a wonderful day. It's evening here. I think it's early morning in the other part of the world. So I hope you have a wonderful day and good afternoon and good evening to all the rest of us this side of the world. Have a wonderful evening.
Thank you for wonderful moderation also.